yay, oh yay. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. Be seated.
Good morning. If you would call the first case, please.
In re E. Marie E.
We'll hear from the appellant when you're ready.
Thank you, Your Honor. Good morning to
Good morning.
all three of you. My name is Nick Bunstein. I represent the appellant, which is Rachel and John Carroll. I'd like to reserve 2 minutes for rebuttal, if I may.
2 minutes, that'll be fine.
Thank you, Your Honor. This is a termination and adoption case. The child that we're talking about is a young lady by the name of Marie or Emery. She goes by a lot of different names because of different spelling. But these parties were divorced in, she was born on May 9th, 2014. The parties divorced August 20th, 2015. They got a divorce in the Sevier County Chancery Court. A permanent parenting plan was entered, mom primary residential parent with 223 days, dad with 142 days. 2016, father moved to the state of Washington, and in 2017, September, the Chancery Court modified the permanent parenting plan and granted and changed it to where mom had 300 days and dad had 65 days. At that time, the court also found that dad had a child support arrearage of $9,718. He was in contempt of court for failure to pay the court-ordered child support and for non-payment of medical bills and failure to provide health insurance. Thereafter, child support in September of 2018, August of 2018, was increased to $827 per month. And father at that time was found to have an arrearage of $18,025.79. After that period of time, father failed to visit the child. My father has not seen this child since the summer of 2018. There's been, from the time that the petition was filed in July of 2021, that stretch, which was approximately 3 years, he had no visits with the child, even though he had court-ordered visits per a modified permanent parenting plan. There's no question that at the time of the trial in December 21, father was behind by his child support of about $45,000. That's an exhibit that was filed in court. And there's no question that not only did father not visit those 3 years, he obviously did not visit the applicable 4 months. At the time that the petition was filed, the child was 7. So from an age of 3.5 to 7, then there was no physical contact with the father. When we went to court to try this case, there was 2 grounds that was alleged. One was that the father had failed to visit in the prior 4 months of filing a petition, and in the 3 years before that. And 2, that he failed to pay child support from 2016 to May 2017. Those were the only grounds. Ultimately, from a child support standpoint, by the time we got to court, there was a wage assignment where the father was paying. We had a hearing after an oral motion to bifurcate to determine grounds only. And after that hearing was done, the court determined that father had abandoned Marie by clear and convincing evidence by not visiting the child for the 4 months preceding the filing of the petition. The court also stated that the mother-stepfather had not significantly restrained or interfered with father's time. Thereafter, we had just a hearing on best interest, and after the hearing on best interest, in March 18th, 2022, the court reversed its decision. Without any notice to litigants or the guardian ad litem, the court basically said, I've changed my mind, I'm going to reverse my decision based on the fact of this case that I found called El Rey Matty, and also based on evidence that was introduced in the phase dealing with grounds. We then, after filed a motion to reconsider, set aside, reopen the case, new trial, all those were denied. The court will see that we basically, in our petition, our appeal, we have filed 3 reasons why we think the court erred. The first is we don't believe the court used the correct statute. And what I mean by that, Your Honors, is that there's no question that he didn't visit. The only question was it willful or not willful? Well, and that's a defense that is through affirmative relief. If you look at the statute, which is that deals with that, it says the defense to abandonment for failure to visit or failure to support, that deal, if you're going to say it's not willful, then the burden shifts to the parent that's saying that. That parent has to prove by a preponderance of evidence that it was not willful. The court never did that in this case. You will not see anything in the record where the court even dealt with that particular issue. The court basically took the position that the mother and stepfather had to prove by clear and convincing evidence that basically that it was not willful. So the court didn't shift the burden. The court never mentioned that the burden was shifted. And not only did the court not do that, the court also, one of the reasons that the court took the position that it was reversing itself is that it took the position because of how far away he was the state of Washington. That is a defense to some degree of him not being able to visit. But that's also not in the statute. That's contrary to the statute, because the statute says that the argument that the parent had only the means or ability to make very occasional visits is not a defense if no visits were made during those 4 years. So my clients take the position that he didn't apply the correct rule of law and didn't apply the statutes as the statute is written.
Did the trial court state specifically as to who had the burden on willfulness?
Did not.
Okay.
All it said, it said it was silent as to that burden, except for it saying clear and convincing evidence was the burden of my client. Now, we also say that the record doesn't show that there's willfully failed to visit. I mean, you will not find anything in this record where the father ever texted mom and say, I'm coming for my monthly visit, emailed mom, I'm coming for my monthly visit, sent a letter, I'm coming for my monthly visit, notifying him I will be at either the police station or the mother's house at so-and-so time, at so-and-so place to do my visit. It is not anywhere in the record, even though opposing counsel has mentioned that 11 times in her response brief that basically he was constantly trying to visit. The record doesn't support that.
So, excuse me for interrupting, counsel. As I understand, during the initial phase, the grounds phase,
Yes, Your Honor.
the trial court made a determination that appellants had not significantly restrained or interfered with the appellee's ability to visit. Did the trial court modify or alter that finding during the second phase?
Yeah, when the trial court changed its ruling, then it changed the ruling on that also.
Made a specific finding with regard to that.
The specific findings, which is another issue, Your Honor, he doesn't really go into the specific findings as how he arrives at that conclusion. And that's an extremely good point, Your Honor, because how can you significantly restrain visitation if visitation is not requested? It's an impossibility. The court, I don't know how else to deal with it. I mean, there's all kind of case law. What is significantly restrains it? You have N. Ray Maddox talks about it, and I'm not going to have time to really spend going through all these. You have N. Ray. Ella, they all talk, and then the other thing I will tell you, Your Honor, real quick before I finish this part of it. The other thing that I would say to Your Honor is the court says, I think N. Ray Maddy applies to this case. N. Ray Maddy is the furthest thing from this case. In N. Ray Maddy, during that 4-month period, the father attempted to arrange visitation 15 times. He showed up at the visitation place. Every time that he showed up or requested, the mom said, no pay, no child. That's not what happened in this case. That what the court relied on in order to kind of arrive at this is is that my 2 minutes right there? Or was that on a
No, you still got your time. She's taken the 2 minutes out already.
Thank you so much. I need all the help I can get, Your Honor.
Let me ask you, upon a review of the record, will we not find any proof that your client said you're behind on child support, so you can't visit?
In March of 2019, my client sent a letter to him saying, basically, I'm tired of you not calling E. Marie. I'm tired of you not being in her life. I'm tired of you not paying child support. Until you resume paying child support, until you can show me you want to be part of her life, then I don't see a reason to do to do visitations. It was a letter out of total frustration, non-payment of any responsibilities, financial or emotional, or you name it. But here's Your Honor, here's the thing about that. If you believe the father, and he really believes that all he has to do is pay child support to see the child, then why does he only make payments of $93 for 20 volunteers? $93. And his obligation's $827 a month. Wouldn't you think that if he really wanted to see his daughter, he would just pay child support if he thought that was accurate? But he didn't do that. Nor did he ever seek any assistance from any attorneys regarding visitation, regarding support during this period of time. He basically just didn't do anything, which was his MO from the very beginning. I know my time is up.
You have your time for rebuttal. We'll hear from the appellee.
May it please the court, my name is Maddie Copes, and I am here with co-counsel Shelley Breeding and Megan Lowe. Today, this court is tasked with determining whether the father's rights, constitutional right to parent his daughter, should be terminated. And in arguing against termination, I'm going to focus on 3 issues raised by the appellants, the mother and the stepfather. As to the first issue, whether there were grounds established by clear and convincing evidence to terminate father's rights, it is our position that father's failure to visit was not willful. In order for his failure to visit to be willful, he has to have a duty, know of his duty to visit or support, have the capacity to do so, make no attempt to do so, and has a justifiable excuse for not doing so. We rely heavily, as the trial court did, on In re Maddie L. I know the appellants believe that that case is not analogous to this case, but however, it is. In March of 2019, the mother sent a long message to the father stating that there is to be no communication with the minor child and the father until he begins paying his child support. Not only was this message sent to the father, the record will show it was also sent to father's extended family. She unilaterally alienated the child from the father's side of the family because she was not receiving the child support that was ordered by the court.
Why didn't he pay?
It's our position that he did not have the ability to pay. He had moved to Washington State when he got out of the military. He moved from Kansas to Washington State, and he was trying to find work. His child support was extremely high. He basically was had to choose between paying child support and trying to pay for a flight from Washington State, approximately 2,500 miles away from Tennessee, to have his monthly visits with his daughter.
So he paid nothing?
When he began working, a wage assignment was put in place, and he did start paying. And that's the case for the relevant 4-month period of March of 2021 to June of 2021.
He was paying that for those 4 months. He was paying under a wage assignment.
Yes, Your Honor.
All right.
Additionally, father was never told of where the minor child lived, which is also a fact that is in re Maddie L. The trial court, in its order, even had a footnote that stated until mother was compelled to provide her residence address at trial, father had no idea where mother or the child lived. In fact, all correspondence and gifts had to go to the maternal grandmother. So to appellant's argument, as he never tried, he never showed up, as in re Maddie L. In re Maddie L, they had an exchange location. Father knew where to go to pick up this child. He also didn't live 2,500 miles away. This father, in this case, lived extremely far away, would incur a huge expense in coming to Tennessee and not even know where to go.
Well, tell me, what did the proof show? First off, do you agree your client had the burden to prove it was not willful?
Yes, Your Honor.
All right, what did the proof presented at trial during those relevant 4 months? What was the proof as to what your client did to attempt to set up a visitation?
So the record will show you that there are messages between the mother and the father where he tried to establish contact with the child, to speak with mother. He recognized that he had not seen the child in a long period of time, and the record will show that based on messages back and forth between the two of the mother and the father, that there were phone conversations between them that discussed reintegrating the father back into the child's life. And you'll see messages that show where father reached out numerous times to mother up until June, and she would not respond, and then filed this petition on July 2nd of the same year. And so it's our position that it was not willful, as mother did obstruct his visitation. He did thwart all of his attempts, which may seem minimal to this court. However, he lived so far away and would incur thousands of dollars of an expense to come here. It's not as simple as just driving down the street to meet at an exchange location like it was in Ray Madiel. As for the best interest portion.
Excuse me for interrupting, counsel. Did father file any petition for co-parenting time or to visit?
He did not, and the same is true in Ray Madiel. He did not, and the father in Ray Madiel did not file any sort of, did not seek any sort of relief from the court until a termination proceeding was filed.
So with respect to his failure to file any type of petition, how would that impact this case?
Based on Ray Madiel, I don't believe that it should negatively impact father that he did not seek relief from the court. He was in a position where he felt like he was under mother's microscope and was required to meet the demands that she set forth. And when he did begin paying child support and did begin to reach out to mother saying, I've started paying my child support, how can we get visitation set up? I'd like to reconnect with my daughter. Mother failed to, either failed to respond, and I believe the record will show on one occasion, she states, now that you've started something along the lines of, now that you've started paying child support, you believe that you can reintegrate yourself back into her life. And that's not fair to the child. That's confusing to the child. And that, and she doesn't even know who you are. But the trial court determined that the child would know who the father is, because even based on, or even during the time where he was not visiting with the child, he was sending gifts. He was sending projects during COVID for her to work on every month while we were on lockdown. She was aware that she has a half-brother because the father has another child in Washington State who this child has never met. But she was aware of all of those things, and the trial court determined that she, in fact, did know who her father was and wouldn't be confused. The second issue that was brought up on appeal by the appellants was that if grounds were to be established that it is not in the minor child's best interest for father's rights to be terminated. However, we believe that the trial court was correct in determining that it would not be in the minor child's best interest if the father's rights were not terminated. We look at Tennessee Code Annotated 36-1-113 as for the best interest factors, and we don't disagree that the factors A and B likely don't weigh in favor of our client, the father, due to the long period of time that he did go without seeing the minor child. However, we do believe that factor C should weigh in favor of the father. While he did not have while he was not able to exercise his co-parenting time and show that he can provide for the child's basic material, educational, housing, and safety needs, the record will show you that prior to the animosity between the mother and the father, when the father was living in Kansas, the father had extended periods of time with the minor child over summer, and the mother had no concerns about the child's safety if her needs were being met. And the trial court even noted that the minor child was much younger then and wouldn't have had the ability to communicate any issues with the mother.
Counsel, I'm sorry. Your client moved to Washington State after he was discharged from the military, correct?
Yes.
And I think the proof was he moved there to be closer to his family.
Yes, Your Honor.
So the proof is that he picked moving to Washington State voluntarily to be closer to his family, as opposed to moving to Tennessee to be closer to his child. Is that correct?
Yes, Your Honor.
Should that enter into our consideration? I mean, you keep saying he's so far away, he's so far away, he's so far away. He's so far away by his choice, isn't he?
Correct. And the mother moved so far away by her choice to be closer to her family here in Tennessee. She was living with the father in Kansas, and upon I believe prior to the divorce, she moved to Tennessee with the minor child. And so, you know, I guess our argument is the door swings both ways, and the mother also chose to move farther away from the father and not help facilitate the relationship between the two of them by staying closer. She moved to her family to have a better support system, and he did the same. As to the fourth factor, we also don't disagree that the minor child and the father probably did not have the best attachment at the time that this trial was heard, again, due to the period of time that they were not visiting. However, there's nothing in the record that shows that they're not able to rehabilitate that relationship. Additionally, father still continued to reach out to the minor child through gifts that had to be sent to the maternal grandmother's address and through letters. I think the record will show that the maternal grandmother believed that communication lines needed to remain open between the father and the child and the father's family and the child during this time frame. And additionally, she stated, and I believe the record will show in a message, that the child thinks of her father daily, and the paternal father, and the father's family daily. As to factor I, the emotionally significant relationships with persons other than the parents
Let me ask you, do you take issue with any of the trial court's findings regarding the statutory factors?
I do not, Your Honor.
Okay.
We believe that, you know, this minor child had a strong relationship with father's extended family in Washington, and that not only was she alienated from father, but them as well, which is further evidenced by mother's message to the paternal grandmother that until father keeps paying his child support, her communication with the minor child will also stop. As for the rest of the factors, as stated previously, we agree with the trial court that they properly weighed those factors. As to the third issue that the appellants raise on appeal, that they were prejudiced due to the trial court reversing its interlocutory ruling, that grounds were not found initially, and then at the close of proof determined that there were grounds. We believe that that is a meritless argument. It is an interlocutory ruling. By definition, that's not a final judgment. It can be reversed at any time. The trial court has the right to change its mind if it hears proof. Appellants were able to put on their entire case as if grounds did exist. They had the ability to put on all the proof that they chose to put on. And it wasn't until they closed their case that the trial court reversed their interlocutory ruling and did determine that grounds did not exist. And that was largely based on In re Madiel and the abandonment issue, and as to whether that was willful or not.
What language do you find in the order that supports your argument that the trial court applied the proper burden of proof with regard to willfulness?
I'm not sure I can direct any specific part of the order. However, I do believe that the statute speaks for itself, that the burden of proof shifts to the parent arguing that their visitation was not willful due to the other parent obstructing their visitation. And I believe that we were able to put that proof on based on the testimony of the mother and the messages between the mother and the father stating that she is to not have, or he is to not have any contact whatsoever, not even communication, let alone visitation with the child until child support begins to flow. I believe we met that burden, and while the trial court may not have specifically stated that the burden shifted to us at one point, I believe the statute speaks for itself, and we were able to meet that burden. And so we would ask that you uphold the trial court's ruling and deny the appellant's request for a new trial. Thank you.
Thank you, counsel. We'll hear from the appellant, hear from the appellant in rebuttal.
Thank you, Your Honor. Your Honor, briefly, there's nothing in the record about the father's efforts to visit. I mean, just nothing. And no, as I said, no text, no email. All he had to do was text or email and say, hey, I'm going to, because he had a visitation every month, I'm coming in on so-and-so date at so-and-so time. I'll meet you here or I'll meet you at your mother's house for my court-ordered visitation. It never occurred. You'll never see it in the record. And the argument that he called her and they were setting up visitation or whatever from opposing counsel, that is not in the record except in his mind, basically. The gifts that they're talking about, those basically were set by his mom. Because his mom was the one that was pursuing time and visitation. It wasn't him. When I asked him a question, why did you not pay child support? His answer was, I don't know. When I asked him, what plans do you have for reunification with the child if the court denies the petition? His answer was, I don't know. At the time that we were in court, he lived in a trailer in the a driveway of his aunt. A trailer has no running water, no electricity, 10 people living in his aunt's house. When you look at the best interest analysis, the predominant theme is stability. When you look how many residences he's been to, how many jobs he's been to, how many girlfriends he's been to, how many alcohol treatment programs he's been to, he's the exact opposite of stability. We take exception to every one of these factors that the court finds are in favor of the dad, because we believe none of them are. Last thing I would say, because I know my time's up, how do we do trial by ambush? How do we do trial, represent our clients when we don't get a notice that the court is changing the whole way things are done? We believe all those are errors, Your Honor. I ask you to grant our appeal.
All right. Excuse me. Court's thanks to counsel for both sides. We appreciate your oral argument this morning and your briefs. We'll take the case under advisement.